Well, thank you for staying with us. This week, Justice of the Supreme Court upheld the election of Abba Yusuf as governor of Kano State, reversing the decision of the Court of Appeal and the Governorship Election Petitions Tribunal, which sacked the governor. Other governors who also got a note of the Supreme Court are Governor Babajide Sanwo-Olu of Lagos, Bala Mohammed of Bauchi, Francis Wufuru of Ebonyi, Caleb Mutfwang of Plateau, Dauda Lawal of Zamfara, and Alex Oti of Abia State, and Basi Oto of Cross Rivers. I have joining me to discuss this Justice Ojeno, lawyer and lead partner, ECO solicitors and advocates. Good evening and welcome to the show.
It's my pleasure.
All right, let's just say there's no more distractions to governance running at full pace. And now the Supreme Court has given its judgment. But let's have your take on this ruling. Any surprises?
Okay, for me, I'm actually very, very happy with the way it went. I was very, very scared, especially for Kano, for Plateau, and for Zamfara states. All the other states, well, it went as we would reasonably expected it to have gone. But even as a practitioner and as an expert in this space, I was scared because I didn't know how Kano would go. I didn't know how Zamfara would go. And I couldn't even guess how Plateau would go. But I'm extremely happy that the way it all went, all tensions were doused, all nerves were calmed, and I'm very, very grateful to the justices of the Supreme Court for actually exercising so much wisdom, not necessarily outside of the law, as a lot of people are saying. A lot of people are saying that the decisions are largely political, but I don't think so. They went frontally and they didn't. There was no holds barred.
All right, let's also talk about how the law will affect the legislators who were sacked by appellate courts, wrongful ruling. You know, as appointed by Justice Okoro, how do you think this should go? Do you think the decision should be reviewed? Okay,
for me, it's a very, very sad one, and these are some of the instances where I actually tell people that sometimes even the judiciary can have it wrong, including the Supreme Court, and I can easily rely on the popular statement of late Honorable Justice Chukwudifo Okuta, when he says that even the Supreme Court is not infallible, so even the Supreme Court can make mistakes. So if we say that, okay, this matter, maybe because it terminated at the Court of Appeal level, maybe if it had gone to the Supreme Court, that there's a tendency that there won't be any mistake. Maybe on this one, yes, but there are other issues too where the Supreme Court can also make mistakes. I have argued that the only institution or the only judge or justice that can never, ever be wrong in its judgment is the Almighty God. So since it's not the Almighty God that is sitting in the affairs of men in this situation, then we should be able to, even though it is very, very difficult, be able to just swallow the bitter pill of, okay, human beings making fatal errors as the Court of Appeal did in this situation. It pains me to a large extent for, not just for the about 25 people who were affected by the miscarriage of justice, despite all settled laws that the Court of Appeal had to decide on this particular case, but much more the people that these representatives are representing. I just pray that this doesn't repeat itself.
So there's no way out for them?
It's only God. And I say this against the background of the fact that the Supreme Court cannot even review it. We must always be reminded that electoral matters are sui generis. They are in a class of their own. They are not dealt with like other general matters. It is extremely sensitive, it is extremely legal and extremely constitutional, and by that I mean that the courts stick strictly to the provisions as provided by not just the Electoral Act, but also the Constitution. So as it stands, some of the things that will affect some of the things that will make judicial review practically impossible is because there's a timeline for filing, there's a timeline for appeal, and all those timelines have long expired. So the Supreme Court, being a court too that is created by the Constitution, and of course the Supreme Court Act also gives it some powers, is subject to those laws, and those two laws do not give it the power to review an electoral matter. So it is very, very unfortunate, and it is very, very painful that even though it is apparent to everybody that this is an injustice committed to the people of Plateau State, it is not one of such cases where we can say that where there is a wrong.
What are the implications of such a thing?
The implication is that a majority of the people, especially of Plateau State, may feel cheated. They may have some loss of confidence in the judiciary. But as much as possible, we should still try to prevail upon them that it is in everybody's best interest that we all abide by the rule of law. We apparently see that it is wrong what the appellate courts did, and the Supreme Court too didn't spare any chastisement against the various panels of the Court of Appeal, but we should just try to let it be, let sleeping dogs lie. It's so unfortunate. Yeah,
you did mention how the court should stick strictly to the electoral reform. And, you know, when this news broke, you see headlines saying something like, Supreme Court corrects the wrongdoing of the appeal court, something like that. And I just want to know, what are the lessons in this ruling, especially for the political parties, INEC, and as well the courts? Because you hear most of the rulings saying the court, ruled wrongly, or even the political parties, they get to bring on board something that should be resolved internally and all of that. And the lawyers as well, sometimes it looks as if they don't know, but it's obvious they know, but I don't know. What are the lessons?
Okay, for me, majorly, I think that the issue of internal democracy, the fact that what a party does within itself, especially in the Plateau State case, what a political party does within its ranks, as much as possible, should not be the business of another political party. And the courts, too, the lesson they learn from this is they will not touch it with a long spoon. They are reminded and chastised that matters of internal democracy are non-justiciable. They are not matters that the court should try to rule on or decide on. They should treat it the way Chapter 2 of our Constitution is being treated, which are non-justiciable matters. It is not a matter that you can bring to court to sue on. As for the lawyers, it's going to be, it's my constituency. Yeah, of course. I know that as much as possible, it is the client that says, okay, this is what I want. Sometimes the client can say, test it in court. And the courts too have abundantly said that if it's a principle of law, a lawyer is at liberty to come and test it. And it is for the judge to say, no, don't do that, not in my court, this cannot fly, because it is just a principle of law that the court has the capacity to cut down, because a lawyer has to actually earn its fees. And the way he earns its fees is by demonstrating industry to try to swerve the court in the direction of his own client. So lawyers may not be, especially on this kind of issues, may not be blamed for this, because it's not so much outside of what we do in courts every day, which is advancing various arguments in order to try to get the court to decide in favor of our own clients. But there are times when it is unconscionable. And when it is unconscionable and a practical total waste of the court's time, or a temptation, or trying to bring the reputation of the Temple of Justice down, the justices of the Supreme Court don't waste any time to chastise the lawyers and punish them directly.
All right.